We will call the next case. This is also a full grant, and each side has 20 minutes of argument. People versus Bean. Ms. Bloomquist, you may reserve time if you wish, but we'll hope that you will try and keep track of it. And you may proceed when you are ready.
Thank you, Your Honors. May it please the court, Heather Bloomquist for plaintiff appellant, the people of the state of Michigan, on behalf of the Muskegon County Prosecutor's Office. I would request to reserve 5 minutes for rebuttal. Your Honors, I know you're well versed in the facts on this case. However, I do want to highlight a few facts before getting into the legal analysis. The circumstances in this case are not limited to a sexual penetration, but rather they are a sexual assault that includes penetration as well as other abusive acts. Now, the victim testified at the preliminary examination that she was falling asleep on a couch at her aunt and uncle's home while they were step relatives, however, family relationship. That the defendant came up to where she was at, placed her legs on his lap, and after she had fallen asleep, she was awoken by him touching her bare legs and then touching her bare breast with one hand while then touching her vagina with his other hand, all underneath the clothes. Now, she did testify that his hand or fingers went inside the lips of her vagina. The Court of Appeals appeared to recognize these facts that went along with the digital penetration in its opinion when it did discuss that there was a touching of the victim's breast while she slept. However, the Court of Appeals, in its opinion, stated that the second-degree child abuse was based solely on the digital penetration. Now, I went through all of the transcripts, the preliminary examination, the motion hearings, and that was not limited in the court's rulings at that stage. So, with that factual backdrop, turning to the statute in question, MCL 750-520B sub 1C supports a charge of first-degree criminal sexual conduct where the sexual penetration occurs under circumstances involving the commission of a child abuse second degree. Now, the primary goal is to ascertain and give effect to the legislative intent and to discern that intent through the plain language. The plain language in this case is unambiguous, and the key phrase is any other felony. And plainly, child abuse second degree, criminal sexual conduct first degree is a felony as established by the penal code. Now, defendant argues that the child abuse second does not qualify as an other felony because it was the same conduct. However, the plain language is not any other conduct or any other act. It is plainly and clearly any other felony.
Counsel, let me interrupt you and just get, in case people have a lot of questions. If they don't, you'll have lots of time left. And I'm going to start with Justice Viviano.
I have no questions right now. Thank you.
Justice Bernstein.
Good morning, counsel. Welcome. I have no questions.
Justice Clement.
No questions right now. Thank you.
Justice Cavanagh.
No questions.
Justice Welch.
No questions.
So I have a question. When I look at the CSC statutes altogether, there's this scheme for age-based CSC, and then the relationship between CSC 1 and 3 seems pretty clear, as well as 2 and 4. And the legislature went to, it seems to have gone to a lot of care to then elevate certain age-based CSC 3s based on sort of a status-like element. You're somebody's teacher, you live in the same household, you're an authority figure. If you can elevate any CSC 3 by using the next section of the statute, the other felony, why would any prosecutor ever proceed under one of those specific status elevating B1 segments? Is my question clear?
Yes, thank you, Your Honor. Well, I think first part of that I'd like to tackle is, and this was also echoed by the Court of Appeals, that this would automatically make any CSC3 a CSC1, which—
Yeah, but I don't, that's not correct, obviously. I mean, that's only true if you actually fit the definition of a person in the child abuse statute. So that's not my question. My question is, why did the legislature go to all this trouble to give us these status-related offenses to elevate CSC3 if you could just do it for any one of those with this other theory?
Well, and I think the distinction from my reading of the statutes together would be the mental harm. Now, all of those other enhancing relationship type CSCs, from my reading, I don't recall there being that mental harm that's a component of it. So I think that looking at the plain language with the intent of it, including it in one statute, but not in the other, that would be one consideration by the legislature in making these separate offenses.
I'm not sure I follow. So you're saying when you proceed on other felony with child abuse as the other felony, you have to show mental harm and that's the difference?
Correct. That is a statutory requirement of the child abuse statute, that there be, and it'd be likely to cause a serious mental harm, is what we're alleging in this case.
Okay, thank you. Justice Zahra.
No questions.
All right, you may proceed, counsel. You have more time, and if folks have questions, they might just interrupt you.
Okay, thank you. Now, I just looking at, and as I've stated, the statutes themselves are separate, distinct felonies. However, as this honorable court has held before, in People versus Ream at 481 Mich at 238, a tool that can be used to ascertain legislative intent is the Blockberger test and a Blockberger type analysis. Now, to be clear, I know this is not a double jeopardy issue before the court. However, using that test as a way to look at how the legislature fashioned these laws, I do believe that looking objectively at each element of these offenses, they are other felonies. They clearly have elements that the other does not. There are very specific circumstances that are encompassed in each that is not wholly encompassed by the other. And further still, using the Blockberger analysis and its progeny, this court, as well as the US Supreme Court, has expressly rejected a same conduct type test that was rejected in US versus Dixon, as well as People versus Nutt and People versus Bobby Smith here. Now, and that same conduct test was rejected for a same elements test. Now, the Court of Appeals here actually held that because this was the, and I'm quoting, same conduct, it could not be an other felony. Now, looking at it with that analysis, I would assert that that's incorrect, and that these are in fact other felonies based on the plain language of that statute. Now, and I'll skip this since the court already addressed it in its question. I would also note in this case that the Court of Appeals, as well as the defense, has stated that there are no increased risks or debasing indignities inflicted and in this factual circumstance. However, I would assert that there are. There was testimony in this matter that an individual being sexually abused by somebody in a position of a parental type role, a guardian, a custodian, that can lead to increased mental harm in these instances. And so that does comport with the prior case law, and that goes against what was interpreted by the Court of Appeals to support that this statutory interpretation that I'm asserting is the one that was intended by the legislature. And Your Honors, at this point, I would open myself up to other questions or reserve remaining time for rebuttal.
You may time unless anybody has a question. I will hold on for a second. Let's see. Okay, you may reserve. Ms. Chartier.
Good morning, Your Honors. May it please the court. My name is Mary Chartier from Chartier and Yamfakutsa, and we represent Daniel Bean. The legislature carefully crafted the criminal sexual conduct statute to classify offenses based on a number of different factors, including the defendant, the complainant, the relationship between the defendant and the complainant, the defendant's alleged actions, and any resulting harm to the complainant. Reversing the Court of Appeals would render nugatory large portions of the criminal sexual conduct statute that take into account these considerations. Based on the carefully designed CSC statute, second-degree child abuse is not an adequate predicate other felony to sustain a charge of criminal sexual conduct in the first degree when the alleged act of child abuse is a sexual penetration that is the same sexual penetration that forms the basis of the criminal sexual conduct charge. Accordingly, we ask that you affirm the decision of the Court of Appeals. As an initial matter, I want to address something that the prosecutor said in terms of the conduct alleged by the complainant. On page 23A and 47 of the preliminary examination transcripts, the complainant alleges that her chest was touched, but she does not use the term breast. Merely touching a complainant's legs is not child abuse, and merely touching the chest of a complainant is not child abuse. And neither of those two facts would rise to the level of criminal sexual conduct. Now, the facts of this case are unique in that the core conduct of the CSC charge is the same core conduct of the child abuse charge, but the ramifications of reversing the Court of Appeals would be enormous. Despite the unique facts of the case, interpreting the phrase other felony to apply to second-degree child abuse would have enormous ramifications throughout the state. It would render portions of the statute nugatory and would result in prosecutors being able to elevate every CSC3 charge to a CSC1 charge if they wanted. Now, I know, Justice McCormack, that you disagree with that, but I would ask the court to consider that when there is penetration, there is also going to be collateral touching. It's almost impossible.
Ms. Chartier, let me interrupt you. All I mean to say is, I think it's absolutely the case it would allow prosecutors to elevate a lot of charges, but obviously sometimes CSC3s are committed by or allegedly committed by people who do not have a position of authority or whatever the child abuse statute requires over, sometimes there are stranger CSC3s. So in those cases, it would not elevate it. That's all that was my point. I'm sorry if I was unclear. Go ahead.
Well, and I may have misunderstood. Respectfully, though, second-degree child abuse is not the only other felony that a prosecutor could use to elevate a CSC3 to a CSC1 where the conduct is the exact same core conduct. So CSC4 could be used as another felony. CSC4 involves sexual touching. It's virtually impossible to penetrate, for example, a vagina without also touching the vagina. Also, a prosecutor could decide to use third-degree child abuse, which is going to be a lesser standard than second degree. They could use other felonies such as accosting or assault with intent to commit another felony. I'm saying these things because it's critical for this court to understand that reversing the Court of Appeals would essentially render nugatory the very carefully designed criminal sexual conduct statute in the state of Michigan.
Thank you for that clarification. I actually hadn't thought about a CSC4 elevating a CSC3. I appreciate that. Let me interrupt you and see if folks have questions, and then we can get back to you. Justice Viviano.
Sorry about that. No questions right now. Thank you, counsel.
Justice Bernstein.
Good morning, counsel, and welcome. I don't have any questions.
Justice Clement.
No questions.
Justice Cavanagh.
No questions for me.
Justice Welch.
No questions.
Justice Zahra.
I guess I'll bite. Under our jurisprudence, offenses are considered distinct if each requires proof of an element that the other offense does not have. And here, these two offenses share no elements at all. As I understand your argument, your claim that the other felony must be a distinct and separate act. And so I guess what permits us to interpret the statute that way in light of our jurisprudence that talks about are the elements the same, and here there are no separate elements. So what is it that gives us this authority to interpret the statute the way you would want us to interpret it?
The rules of statutory construction, for one. if this court were to determine that the government's position is the prevailing position, and I agree, there is some superficial and surface level appeal to the argument that second-degree child abuse and criminal sexual conduct they have different elements, they have a different statutory number, they have a different name. So they must be other felonies under the statute. But if the court examines what that would do to the criminal sexual conduct statute, the rules of statutory construction as well as the rule of lenity would prevail. So if the government's position is the one that carries the day here, then the entire statute, or at least portions of it, are nugatory. Because in addition
let's stop there. The entire statute being nugatory, I look at that as a question of statutory interpretation. But portions of it, no. The legislature can do that. They can create a statute that would I don't want to say override, but would take precedent in this case because they're completely separate and it's other felony. It's only if it completely emasculates the statute, and I don't see that here.
With all due respect, I disagree. So CSC 4s and CSC 3s really are no longer if a prosecutor wants to enhance to CSC 1 and CSC 2. We're not just talking about the circumstances of this case where it's a child 13 to 16. Any adult who's charged with the CSC 4 could have it enhanced to CSC 2, or any adult charged with CSC 3 could have it enhanced to CSC 1. That's certainly not the intent of the legislature for prosecutors in each county to determine that they don't have to follow portions of the criminal sexual conduct statute. If the legislature wanted every CSC 3 to be enhanced to CSC 1 because there was collateral sexual touching when an individual was penetrating a vagina, for example, then we wouldn't need a CSC 3 statute. And the rule of lenity, when you have a statute that is ambiguous, inures to the benefit of the defendant. So in this case, if the court believes that the statute can be read in either way, and we know 3 judges on the Court of Appeals believed it could be read in favor of the defendant, then the end result would be the affirmation of the Court of Appeals because of the rule of lenity. No Michigan citizen believes that the legislature writes a law and then prosecutors can ignore it. And that's what reversing the Court of Appeals would do. It would render prosecutors to be in the position where they can have this hammer on individual defendants. And that's what happened to Mr. Bean in this case. This isn't some construct that we came up with to talk about some occurrence to try and make this seem more frightening. Mr. Bean was charged with criminal sexual conduct in the 3rd degree. When he did not plead guilty, he was enhanced to criminal sexual conduct in the 1st degree. And that happens and can happen throughout the state if this court reverses the Court of Appeals. And we know that innocent people do plead guilty because in a report by the Innocence Project in 2017 of the DNA exonerations, 11% of the individuals exonerated had pled guilty. They were actually innocent people who looked at the cost-benefit analysis of continuing to go forward to trial when there are onerous penalties, and they decided to plead guilty. So we're not talking about a law school hypothetical here. We're talking about real people who are going to be faced with penalties that are at least double in many cases and significantly higher. Reversing the Court of Appeals will result in more innocent people pleading guilty because of the absurd result that would occur by allowing prosecutors to ignore CSC 3s in favor of charging them as CSC 1s. This absurd result was certainly not intended by the legislature, and it's not supported by the statutory language when the entire statute is looked at as a whole. This court cannot just review portions of the statute, it needs to look at the entirety of the statute. Absurd results would occur if this court reverses the Court of Appeals. The proportionate penalties that the legislature took care to draft would be no longer at issue if a prosecutor in a county seeks to enhance every CSC 3 to a CSC 1.
Thank you.
The government hopes that this court adopts its position, and this is going to result in very real consequences for Michigan citizens. The Court of Appeals properly considered in this case that context matters when examining the words of a statute. The court appropriately looked at the entire statute, and they consulted a dictionary to discern the words ordinary meanings. Ordinary meaning is not found by going to Westlaw. An ordinary citizen doesn't have access to Westlaw, and quite frankly, some lawyers don't either. The words in a statute matter to ordinary citizens as to how they would understand the words. And the word other is the one remaining or not included. And here there's a complete overlap of the core conduct at issue. There's nothing in the record about touching a breast. There's nothing in the record to support that claim. There is in the record allegations of touching a chest, but again, touching a chest and a leg is not child abuse or criminal sexual conduct. Because there's no other felony here, the core conduct is the same. The Court of Appeals decision comports with the rationale of the legislature wanting to punish the combination of sexual offenses and other felonies by treating the sexual acts as major offenses when they occur under circumstances involving the commission of any other felony. Looking at the circumstances here, reversing the Court of Appeals would result in an absurd result. There's no direct interrelationship between the felony of child abuse and the felony of criminal sexual conduct, because again, the conduct is the same. The government essentially wants to double count the penetration and punish Mr. Bean for not having entered a guilty plea when he was only charged with CSC 3. We're not asking the court to legislate from the bench and rewrite a statute, and the Court of Appeals certainly did not do that in reaching its decision. We're asking the court to read the language of the statute as a whole, as an ordinary person would read it. And an ordinary person would not think that the gradations in the statute exist, but that a prosecutor can eliminate all of them at their whim. We're asking the court to look beyond the surface level analysis of the government's position and consider the tremendous impact of reversing the Court of Appeals. It's the government's position that would rewrite the statute because it would render portions of the statute worthless. The legislature did not intend for each county to have a prosecutor who could eliminate CSC 3 and CSC 4 in every single case if they want. That's not protecting the rights of Michigan citizens, it's trampling them. The government's position runs counter to the plain meaning of the statute's language and the legislature's intent, and it would have an absurd result affecting Michigan citizens. Additional months and years in prison are not just numbers. They affect defendants, their families, and entire communities. The government's position ignores this as well as the rule of law. Accordingly, we ask this court to affirm the decision of the Court of Appeals. Thank you.
Thank you, counsel. Does anybody have additional questions for Ms. Chartier? Ms. Bloomquist, you have some rebuttal time.
Yes, thank you, Your Honors. First, addressing the factual dispute that I believe was drawn out in opposing counsel's statement. Yes, the victim did testify that her chest was touched. However, she indicated it was under her bra. And so using reason and common sense and applying our reasonable inferences to the facts, like if we're sort of sitting in the seat of a juror, that would make the reasonable inference that her breast was touched on the bare skin underneath her bra on her chest. So that's to give the other facts that support the touching and my statement that there was a touching of a breast. Now, the other thing that was additionally brought up is that this was done in some sort of malicious or vindictive way to try to force some sort of plea to a CSC third. Now, that's not accurate. And obviously this court's held multiple times that a prosecutor has the discretion to amend an information at any point in time, as long as it does not arise to unfair surprise. Now, obviously this was done before trial, well before trial. A remand was authorized to send this back for a preliminary examination on the amendments. Now, additionally, if the facts support it, which they do here for that, I don't see how that could be any sort of issue that would be present in this matter. Now,
Counsel, can you respond to the hypothetical that you could always elevate a CSC3 based on a CSC4, and most CSC3s are going to include a CSC4? Do you believe that's a valid way to proceed with this other felony provision of the CSC statute?
Your Honor, I do believe that that is something. If you look at the plain, yes, I guess short answer is yes. I do believe that is something that could be done. However,
then why did the legislature go to the trouble to outline all these specific people who could have their adults who could have their CSC3s elevated in 1B? Why did they go to all that trouble? They're all carefully, sketched out. If every, CSC4 can elevate it.
Your Honor, I think that my interpretation of it, and I believe the plain reading of it, is that word any. Any means all and every, and it does not have limit. And so,
but we don't read it in isolation, right? I'm just asking. We don't read it in isolation. You read the whole statute, and it just feels like they did a lot of work to figure out which adults should have their CSC3s elevated for good reason, right? They're people with a kind of a position of authority over kids.
Mm-hmm. And Your Honor, I think that ultimately that is the legislature sort of giving some prosecutorial discretion as to the facts and what to have charged ultimately, and what level.
You choose it. They're so much harder to prove under 1B because you have to, in the position of authority, for example, you have to show that position of authority helped, coerce somebody. I mean, I would always just go with the CSC4 or the child abuse if I had it, right? It's so much easier. I mean, in my next career as a prosecutor, that's how I would do it.
Well, and Your Honor, I think that when the legislature drafts these statutes, they do account for the varying ways that it could be charged and could be pursued to allow for that prosecutorial discretion. And I don't see this, the reading as inconsistent when we have the legislature's very plain, very clear, unambiguous language of any other felony. So I know we're not here today before the court on alleging a CSC4 or that, but rather this mental harm, which I don't see that as rendering any portion of the CSC3 statute nugatory for that reason.
Thank you. Any additional questions? Let me see if anybody has any additional questions for you, counsel. Okay. Are there additional questions for Ms. Bloomquist? Any closing remarks?
Your Honor, yes, thank you. I do believe that the Court of Appeals should be reversed in this matter, and that their holding is inconsistent with the plain language of the statute and the legislative intent. Now, if the legislature wants to amend the statute to address some of the concerns that were encompassed in the Court of Appeals opinion, that is for the legislature to do, and I believe the plain meaning of this language does allow for this case to proceed as it is currently charged as a CSC1 with any other felony being a child abuse second. So I would ask the court to reverse the Court of Appeals. Thank you.
Thank you both. The case will be submitted.